Welcome to Family Law Uncovered, a series of podcasts from Thursfields Solicitors, one of the leading law firms in the Midlands. My name is Shane Miller, a director and a head of the family department here at Thursfields, specialising in all areas of family law. Today, I'm joined by Christopher Walklett, a forensic accountant and tax expert from Bishop Fleming, the award-winning firm of chartered accountants who regularly work with Thursfields on family law cases. Today's episode is all about expert witnesses in family law cases, and Chris and I will be discussing the details of when an expert should be instructed, why they can help, and what it means to be an expert. Hello to you, Chris. How are you?
Hi Shane, great to join you. Thank you for having me on Family Law Uncovered. I'm very well. How are you?
I'm good, thank you very much.
Very good.
So Chris and I have worked together on many cases dealing with family law matters, and I've always found Chris's advice and expert opinion to be invaluable. When parties separate and a business is involved, it can often mean that you need some input and help from other professionals. For example, evaluation of the business, or understanding the tax consequences for parties should they separate and or transfer ownership of their business or shares. Chris, you work for Bishop Fleming, an international accountancy firm, and you specialise in tax and value in businesses. Can you summarise for the listeners exactly what an expert witness is, please?
Of course, a court is obviously full of learned people, the judges, the instructing solicitors and the barristers, but there are some areas that will be outside the area of the court's expertise. So that's where the expert witness comes in, and we have the privilege and responsibility of being able to express an opinion. So we're not witnesses of fact, we're witnesses of opinion, and that's, as I said, is a privilege and a responsibility.
And what is an expert witness's obligation to the court? And can you please outline the importance of your role as well?
The obligations and duties of an expert are laid out in regulations, as you might expect, the Family Procedure Rules 25 and Part 25, and also CPR 35, so they're the regulations. And it's an interesting dynamic for a professional, because you as the instructing solicitor are instructing me and I have an engagement with you, but you're not actually my client. The client is the court, and my duty is to the court, which is scary because the court has a judge in it and really don't want to incur his or her wrath. As I alluded to earlier, the court is looking to the expert to try and demystify an area of complexity. The judge is there to try and conclude and opine on an outcome of that case. And there'll be times when there's a degree of complexity that the witness is there to unravel. But if you're a single joint expert, you're acting for the court to help the court, you've got to be impartial. This isn't about taking sides or making judgments. I'm there to help the judge pick apart the complexities of a case for which I'm subject matter expert. In terms of responsibility, the ultimate sanction, if I fail in my duty to the court, is I could be struck off. I could be referred to my professional body and struck off. And that's happened. There is, the Jones and Caney case is a pivotal case, which reversed 400 years of immunity from prosecution for expert witnesses.
So if I may pick up something that you said, was that you're regulated by some of the civil procedure rules and the family procedure rules. What do you do if somebody doesn't comply with those and you're an expert witness?
I think it's about keeping a cool head. I took the decision many years ago to do the formal training, which has been invaluable in terms of just taking a step back and informing what best practice is in whatever situation. The ultimate approach I can take is I can actually independently approach the court for a direction. I'm effectively going back to the judge and saying, I need you to clarify my instructions. I've been asked to do this. One or more of the parties are frustrating me in my attempts to execute my duty to the court. Please, can you direct me as to what I should do about it? And I have had cause. I've never got as far as writing the letter, but I have had cause to threaten it. And that usually focuses minds.
Absolutely.
But I'd rather not get that far, to be honest.
No, I can understand that, but sometimes it must be challenging for you if people do fall outside of those rules and your remit. And it's having, I suppose, those your own integral obligations, your own ethics, your own position to make sure that those rules then are complied with.
Definitely, and it can be a lonely place being an expert. Invariably, at least one of the parties won't be happy with what I've done because the outcome may be, maybe positive for one and not the other. More often not, neither of the parties are happy with the outcome. And in fact, in a sort of strange way, that might be the right outcome. If one party thinks I valued something too high and the other way, then I've probably just about hit the sweet spot. But I come back to, I sign those expert witness reports. It's me that's signing it. I don't sign on behalf of Bishop Fleming. It's my reputation and ultimately my career that's on the line if I don't do my job properly.
Yeah, I understand that. And perhaps we can tell the listeners if you could give an example of when an expert witness might be needed.
So as alluded to earlier, a judge will have obviously a substantial amount of expertise. They will very likely have seen matters as to valuation tax before, so they'll have a good grasp of it. But there will be times when that level of complexity of the fact pattern of the business or the instructions is such that the judge needs that assistance for the expert to come in, write a report, and I would call it bringing order to chaos. And by that I mean you've got a chaos of data, loads of different data that's being presented as fact, which might not be. You'll have the parties giving their opinion. Obviously, they'll be driven by emotions and their own agenda in terms of wanting an outcome. The same for instructing solicitors in terms of the outcome they want for their clients. Ditto the barristers. And a judge that is compelled by FPR Rule 1.1 to hear cases expediently and justly. So I have a responsibility to try and bring all of that together. It's a chaotic mass of fact, opinion, and emotion, and I need to try and give the judge some clarity in an objective way and say, this is how I see it, this is my opinion.
Yeah, of course. I really like that phrase that you just said. What was it?
Bringing order to chaos.
Yeah, I really like that. That is exactly it, isn't it?
Which is ironic because some of my colleagues will tell me I spend more time bringing chaos to order, but we can do that on another podcast.
But obviously, the organised chaos, as you say, it's providing that defined opinion, isn't it? And ultimately, a valuation or a range for the court then to have that information before them, so they're able to make their decisions then.
Yeah, and I think that's crucial. It's the court making the decision. I'm not making the decision. When I first started the training with Cardiff Law School, they asked these very questions you're asking, actually. Before, when we were raw rookies, I thought we knew all there was about being an expert witness. They said, what's the role of the expert, do you think? What's the duty? And I, being the opinionated, outspoken chap I am,
never.
I stuck my hand up and I said, well, to help bring some justice to the case, and something the barrister would stop laughing. He said, no, Chris. He said, that's the judge's role to judge the case. Your role is just there to assist the judge in understanding an area that's outside of their area of expertise, so that they can do their role. But it's not my job to judge the case. I'm just there to, and I think that's where I need to give the judge and also the parties. Sometimes I will write a report. It won't end up in court because the parties will look at my report. They will use that as a discussion document, and it will find them a way through to find a pragmatic solution. I'm not telling them what that solution should be. I'm just giving my opinion as to how do the facts inform a possible outcome in terms of valuation or what the tax might be.
Yeah, I think as well, we can't forget that often in cases when we do have a joint expert, that when the report does come in, it often leads, as you say, opens up negotiations for parties. And sometimes then parties are able to settle without then having to go back into court again. don't they?
Yeah, exactly.
Really useful tool.
And interestingly, on one of the cases where I threatened to go to the judge and ask for a direction, it focused minds, and the respondents were pretty much, I wouldn't say caved in, but it brought him to his senses. He realised that I was steadfast in my duty to the court, and literally, I gave instructing solicitors per the procedure. I gave them notice that I was going to write to the judge. Within about 24, 48 hours, I had a response back to say the parties have met and concluded and agreed a compromise, which was great in that case.
In your position, sometimes you already mentioned how it can be such a lonely place.
Yeah.
But sometimes I think that's going to be hard in your position when you have solicitors or the parties approaching you direct saying, I don't agree with it. What happens if it's about this? And trying to persuade your opinion in one way or another.
Yeah.
How do you combat that?
Oh, that's an interesting question, because actually underpinning that has its roots in psychology.
Mm-hmm.
Because, as I said at the start, I have the privilege and the responsibility of being able to give an opinion in court. A witness of fact is not able to do that. The problem with opinion is that we are wired over millions of years of evolution to form an opinion. We form opinions quickly. And the theory goes that you form that opinion because it might save your life. It's a fight or flight type scenario. You form that opinion. And as human beings, we don't then reform that opinion if the facts tell us something different. So one of the biggest challenges, and I learned this, I went on a course which was called Interrogation and Deception Detection. So I turn up on day one and I just think, it's fantastic, I'm going to learn some interrogation. I'm going to learn some interrogation techniques. The first thing we were taught was not how you elicit facts and contradictions from the person you're interviewing. The first thing we were taught was how to control our own mind. In an area called cognitive dissonance, and it's where we form an opinion, and if we start getting presented with facts that contradict that opinion, we are actually wired not to change our opinion, but to reframe the facts to fit the opinion. So if some facts contradict it, we're going to ignore those. And if some facts actually sit and support the opinion, we focus on those. Why is that dangerous and relevant in this case? It's because I need to be impartial. I need to see those facts, form an opinion, and then if I see further facts and I should be reflecting on my opinion and change it, there's a risk because of how human psychology I want, and I need to be doing that. I need to be challenging myself on that. And I often see this when I act as a shadow expert. I'm asked to review a report that another expert's done, and I write questions, and you put those questions to the expert. It's very, very rare for an expert, in my experience, to say, "Yeah, actually, that's a good point. I'm going to change. I'm going to change my opinion." It's fascinating, absolutely fascinating.
I could imagine, yeah, definitely.
And I think another point, just at the top of your question there, in terms about being overly led by one of the parties, the Jones and Caney cases, where an expert witness was just acting. She was a doctor. She was acting for one side and I think it was in a clinical negligence case or something of that ilk. She was giving evidence, and she admitted at the end that she'd been put under pressure to give the opinion that she had, and she admitted later on in the case that she'd been skewed,
influenced,
and she had failed in her duty in terms of being objective and not being persuaded or biased to either side. And the ultimate sanction there was the judge referred her to a professional body, and she was struck off. And 400 years of history that got us to a point where you were immune as an expert witness from prosecution or sanction. You hadn't basically, it just tore that apart. You lost immunity. And again, it's why it's so important that experts know what the duty is to court. They're familiar with the regulations, because that's the sanction that you're facing.
I think our listeners would be interested in when and why you would need a report and what kind of value then it adds to a case.
The report is there to walk the parties in the court through, okay, what was I instructed to do? What did I do? What documents and facts were relevant? What aspects am I presenting as facts, or which aspects am I presenting as opinion? And then ultimately, what are my conclusions for each of those instructions that I've been given? What's my conclusion? What's my opinion? And that document is then before the parties in the court to work with, for them to either reach a mediated solution, or ultimately, if they can't agree, the judge to take it and take a view.
So generally, I think your expertise are needed, aren't there, when there's invariably a business involved, or there's some complicated tax calculation which needs to be undertaken. And when the parties provide financial disclosure, which is what they do in family cases, sometimes the information which is provided by one party may not always be what the other party expected or believes. So that's, I think, is when we say to the court as instructing solicitors, please can we have a valuation? And then you are instructed to carry out that valuation and or computations of any tax, isn't it?
Yeah.
And we've already been through, haven't we, why the court will need that information. But what value do you think it really adds to the case for the individuals who were going through it at the time?
Well, if you step back, the judges will only instruct expert witnesses if they really have to. They have an obligation to hear cases expediently and proportionately, so they're not going to incur cost, and they do not want the parties to incur costs or delays unnecessarily. But invariably, there will be areas that are outside of that judge's expertise, the party's expertise, or the judge feels that this is a material matter. We need an objective view on it. So the value of that report is, well, I think the first thing is that the process of surfacing all of the facts, or trying to surface what is presented as fact and really is fact, that starts us down the journey of forcing the individuals, or hopefully obligating and getting them to focus on being honest and open about the facts, the business, the accounts, what's gone through the accounts, the fortunes of the business and everything. So that process of saying, okay, we've got a formally instructed expert now, that's a named expert, that expert is on the judge's radar, the judge is expecting the expert witness to go through that process and then curate everything they've done into a report. You've now got a report that, if I've done my job properly and I'm demonstrably been diligent and professional, you would like to think that instructing solicitors and barristers that have faith in that report will talk to their clients and try and find a way through and a solution. But ultimately, if they can't, you've got a judge that can look at it and say, right, based on this report, I understand the facts, I understand the business, I certainly know a lot more about the changes to the tax rules that are coming in April 2023, and I'm in a position to try and give some direction as to what the value might be on this business.
So if someone wanted to instruct you, what would you say needs to be included within those instructions so that you could provide the best report that you can?
So we come back to the judge's role and the instructing solicitor's role to help the judge in their obligation to hear a case expediently and proportionately. I need to give the parties a quote. The more understanding of the business I can get, the easier it is to give me an accurate quote. I don't want to be in a position where I quote too low and then end up,
having those difficult conversations.
I am an expert. I take my role very professionally, but ultimately, on a commercial level, I can't spend £10,000 of time and get £2,000 as a fee for it. But also, and I think more important, if we can just part that commercial aspect, I need to be able to understand what I'm being asked to do in the context of the businesses. Is it one business? Is it three businesses? Are these three businesses grouped together? So that I can start to shape my thinking about what might be relevant. And in some instances, go back to instructing solicitors and say, you've asked me for a quote to do this. You've said there's 2 companies. I've checked. There's actually 4 companies. Are you sure these instructions are accurate? Because again, I raised this as part of the training course we were doing. So what happens if you get some instructions and you don't actually agree with the instructions? And I thought the answer back was going to be just do as you're told. Well,
Yeah.
they're your instructions, get on with it.
Yeah.
But actually, no, the court is looking for the witness to say, okay, if you think there is something suboptimal about what you're being asked to do, or there's an elephant in the room, you need to shout about it. But really, I want the stat accounts, if I can, get the detailed statutory accounts for each business, how it's owned, and is it a group, that sort of that's really, really helpful.
Your title is that you're an accredited expert witness. What does it mean, and how do you become accredited?
So there is the main training provider for this is Bond Salon, who've got a joint venture with Cardiff Law School. You attend a number of courses. At the end of it, you have to submit a written exam. You are cross-examined, so you have to submit a report that you've done, but you obviously redact and anonymise it, and it has to be on a case that's already closed. So you submit that, and that report gets marked by the law school for how appropriate it is in terms of its structure. But you also get cross-examined on it. You get fiction. You get put in front of a barrister in a fictional court and cross-examined on it to test how you would cope if you were cross-examined.
That pressure. Mm-hmm.
And we obviously, as part of the training, you submit a different report. You have to submit a different report as part of the training. So the first time I was cross-examined, as part of the training, I got my report the night before. I'd read through it. I thought, I'm all over this. I've got this
fully prepared.
I've got this licked. I'd even done some research that said, don't be a smart aleck. Answer the question. Don't try and get into a debate with the barrister because you're not going to win that. Just be clear. So I was all there ready to answer my report. And I got totally torn apart. Because there I was ready to answer questions on the report with conviction. And the barrister opened with, so tell me, Mr. Walklett, it says on here that you're part of the HMRC's expert witness panel. You're not really, are you? That's just rubbish. I'm just looking down your other qualifications here. I think you're misrepresenting it. I think this is rubbish, isn't it? And at that point I go, what? And then dives into some questions about the report, at which point, because I'm flustered.
Yeah, off guard.
And I'm off guard and I'm not answering the questions well, the barrister has achieved the route 1 approach. And forgive me, any barristers listening to this podcast. I do hold you in high esteem, don't worry. It's a lot easier to undermine the witness than it is to try and pick apart the facts. Just destroy the witness if you don't like what the witness has done in the report. And the beauty of that training is that after being battered and bruised a few times, when I came to do the actual exam, I was all over it. And simple things like, you might have written, a 60-page report. Well, the barrister might say, well, tell me, Mr. Walklett, take me to the part of your report where you talk about this. They won't say it's on page 30, section 5.3, because they want to see they want to demonstrate that you're not bossing your report. So when I was actually cross-examined for real in an actual case, and that happened, it was more that the barrister was trying to find something, and I had to pipe up and say, I think you'll find it's on that page. So I was actually helping the barrister find it as opposed to the barrister trying to catch me out, which I would never have been able to do if I'd not had the training. And I would urge anybody that's acting now as an expert witness or is thinking about it to do the training. It is a real wake-up call. It is a fascinating insight to how the law works. Not only has it spurred in me the desire to do my job properly, but actually, because I understand the ramifications, I take a real interest in it. And when you're interested in something, you're going to do a better job. You're going to want to do a better job. It's just natural, isn't it?
Yeah, absolutely.
And it's scary. On the first time, the cross-examination example I was referring, that first time we did it, there was 8 in the class, and each of us took turns to be cross-examined by this barrister. One of the experts was a child psychologist, and she'd been previously involved in a high-profile case, which I won't mention, but if I mentioned it, everybody would know about it. And she'd been cross-examined before, but not had the training. This was a practice session, and she was in tears at the end of it. But at the end of the training, we all said, I'm so glad I've done that.
Yeah.
Because I feel I've just got that. I know what I'm doing now. I know the seriousness. I know the protocols. I know how to bring my subject matter expertise and deliver it through the prism of what the Matrimonial Causes Act and the Family Procedure Rules are expecting of me. It's the best thing in terms of training. It's the most interesting thing I've ever done.
So when you prepare your reports, how do you get to the conclusion that you've come to? And what conclusion do you usually get to? So obviously you've been instructed to provide a report, but often than not, I assume it's a valuation. Sometimes it might be tax computation. Sometimes it might be about income.
So the process I go through is I send out what I call it a fact find. It's a tailored questionnaire. It's designed to elicit all the relevant information you expect, accounts, management accounts, shareholders agreements, articles, group structures, who owns what, actually clarification of my take is this, I'm valuing this, do you agree? All of that stuff that you would expect to be asked for if you were valuing the business. So I take that. I also do the open source intelligence piece I was talking about. So we're digging into Companies House and databases that tie into that. If I've got if I've got a husband or a wife owning a business, and they, I've had this before where they've said, because obviously they've got that, they have a desire for that business to be valued as low as possible. And, you can understand that. So I will have representations such as the business is really struggling, we're having to make redundancies. So I will go straight onto the website. I will go onto social media, the LinkedIn page for the company or the directors, Twitter feed, Instagram. I've not got as far as TikTok before. That would be a bit extreme. And what do you find? You find the business is showcasing some great contracts it's won. It's advertising for new personnel. And you can just put that. You can just say, "Well, hang on a minute. You're telling me this, but I'm saying this." So you bring that together. I take the data, I stick it into an Excel model that helps do the valuation. There are things like multiples. For those that know about valuation, you take the profit figures and you apply a multiple to it. Well, I need to go and research where I get that multiple from. There's a number of indexes. I have access to a tool that reports actual real deals, so you might be able to find some comparators. And again, I have to exercise some judgment because, again, in order to chaos, I might have an index telling me I need a 6 times multiple. I might have an actual deal that gives me a 10 times multiple, and I have to work out which one of those it is. Now, actually, the husband might say, well, it's a 6 times, or the wife might say it's a 6 times multiple because this business is a busted flush.
Is that the area that you get the most challenge on?
Yes, I think there's 2 areas of challenge because of the subjectivity. The multiple, definitely. And then if you're looking at it, when you're applying a multiple, what you're applying it to. You're applying it to the earnings you think that the business can sustainably make in the future. But often you're predicting the future based on what's gone on in the past, the historic accounts, and you will probably take the last three years and average them with adjustments to try and normalise and get to the underlying. But sometimes you use a weighted average. You might weight the most recent year more heavily than later years because you're going to say more contemporary data is more representative of the future, but it might not be. COVID has meant that we've got very fluctuating both ways.
Yeah.
And
I bet that was such a challenging time, wasn't it?
It was. I'm old enough to remember back to 2008 crashes where we had businesses with fluctuation and the same sort of problems were happening then. And the approach I've taken is actually, instead of maybe looking at 3 years, I've looked at 5 years and weighted them equally. And one of the benefits of doing that, of course, is that if one of the parties has tried to manipulate figures going through the accounts, you're not at risk of unwittingly overemphasizing that that manipulation. Because of course we have to remember as experts that you might have a company with let's say an October or November year end. So I'm looking to get those draft accounts ASAP because they're contemporaneous, they're very relevant. But the business owner, be it the husband or the wife, will have known probably 12, 24 months, maybe even earlier than that they were going to get divorced. So they're already thinking, right, how can I manipulate these accounts to just depress them? And it happens. It happens. It's human, and it's understandable that it happens, but you have to be alive to it. But coming back to that point I made about cognitive dissonance earlier, not only do I have to be alive to that it could have happened, I also need to be alive to don't assume that it has happened and get sucked into some unconscious bias, being biased against the business owner. I mean, you've told me that you're making redundancies, but I can see some social media that you're not. Well, I can't take that social media evidence and take that as the only evidence I'm going to take. You could be so careful with those errors, where there's those judgment pieces. What multiple will I use? How do I weight the years? Am I going to look for forecasts, management accounts? I've just got to be so careful that I surface the facts and then do something balanced with them.
Finally, Chris, if anyone was to become an expert witness in your field, in your role, what would be your top tips?
The first is just be comfortable that you can be an expert with conviction. I'm an accredited expert witness, but just because I've done the law school exams doesn't mean that I'm a subject matter expert. It just means I know how to take that expertise and present it to the court. You need to be a subject matter expert. If you represent to the court that you know your onions in a particular field of psychology, business, valuation, whatever it is, and you are not a subject matter expert, you are going to waste a lot of the court's time and incur the judge's wrath. And as you're aware, there have been cases where that's happened. So the first thing I'd say is, are you really a subject matter expert? If the answer is yes, then my second tip would be do the training, do the Cardiff Law School exams, because I spent most of the courses sat there thinking, I'm so glad I'm doing this. And I can't believe anybody would think about being an expert that hasn't done those exams. So they would be literally the first two main tips. The third one would be aware of the psychology. You're there to be impartial. It's human nature to very quickly become biased towards an opinion. You've got to continually challenge your opinion and, if necessary, reframe that opinion to fit the facts, not the other way around. You need to remember that you're signing the report, you're the expert. You might be working for a firm like mine, for Bishop Fleming or whatever your accountancy firm is, but for that moment in time, you are not working for Bishop Fleming. You have been instructed as an individual that is signing that report. And it's your reputation and your career on the line. And of course, the firm you're working for may lose reputation if you don't do your job properly. But you've just got to realise how serious that is. But then the flip side of that is the fourth thing I would say is use your training, keep going back to it. When you're concerned that you might be getting sucked into something, or the case is stagnating, or you're getting frustrated, just go back to your training and go, right, my duty is to the court. Actually, the court wants me to do the best job possible. They're actually there to support you. Judges want the expert witness's help. If you need to, go to the judge, get them to help get you out of a hole if the parties aren't playing ball. If you stick to the training, that's your comfort blanket, and you can't go far wrong if you do that.
Christopher Walklett, a partner and tax expert from Bishop Fleming. Thank you very much for joining us today on Family Law Uncovered.
Thank you, Shane. Thank you for the opportunity.
So thank you to our audience out there for taking the time to listen to us and this podcast. Hopefully you have found it both enlightening and useful. You can also find out more about this subject by visiting Thursfields' website, www.thursfields.co.uk. We will be back next month when Jill Roberts will be exploring mental health and how divorce has an impact on that, with Rebecca Hanson from Becky Hanson's Counselling. Family Law Uncovered, an original podcast from Thursfields Solicitors. Thank you for listening.